Are we supposed to send SEAL Team 6 into CCOT to extract this terrorist, Kilmar Armando Abrego Garcia, who's had a final order of deportation in his back pocket for 6 years? But as explained, a federal court cannot compel the Article 2 executive branch to engage in any mandated act of diplomacy or incursion upon the sovereignty of another nation. Garcia invites this insane court of unelected, black-robed, tyrannical, inferior district trial court judge Paulison to exceed its own authority in the precise sort of way the Supreme Court cautioned against, dummy. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day Law of Self-Defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. Declaration of Michael G. Kozak. So remember, Paulison, unelected black-robed tyrannical district trial court Judge Paulison ordered the White House to send forth to her courtroom every day by 5 p.m. someone who would declare under penalty of perjury the answers to her 3 questions. 1, what's the location and status of our beloved terrorist Kilmar Armando Abrego Garcia? 2, what steps have you taken, White House, so far to facilitate his return to the U.S., which the Supreme Court never called for? And 3, what steps do you plan to take in the future, White House, to facilitate his return to the U.S., which the Supreme Court never called for? All right, so Michael G. Kozak, senior bureau official in the Bureau of blah, 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 blah in the State Department. He's responsible. He sets forth his responsibilities here. He's aware that there's an instant, meaning current, lawsuit filed to return Kilmar Armando Abrego Garcia to the U.S. from El Salvador. I provide this declaration based on my personal knowledge, reasonable inquiry, and information obtained by other State Department employees. So here he's trying to protect himself from a perjury charge by this judge. Listen, this is the basis for my knowledge, right? It's imperfect. I'm in part relaying what other people are telling me that I don't have a real way to confirm, but an understanding and belief, as lawyers put it, this is what I believe to be true. And then he only answers the first question of the 3. It's my understanding, based on official reporting from our embassy in San Salvador, that Abrego Garcia is currently being held in the tropical El Salvadoran prison resort terrorism confinement center in El Salvador. He is alive and secure in that facility. He is detained pursuant to the sovereign domestic authority of El Salvador. That's his answer to question 1. What's the location and status of Abrego Garcia? He doesn't address questions 2 or 3. What are you doing to facilitate his return to the U.S.? At all. He ends there. I declare under penalty and perjury. 12th day of April 2025. He signs it. You think this got unelected, black-robed, tyrannical, inferior district trial court judge Paulison? You think this kind of response to her imperious order got her a little hot under the collar? I bet it did. I bet it did. This was not a sufficient bending of the knee for her satisfaction. What about the next day, Sunday? Again. And by the way, I think this order was delivered like 5 or 10 minutes after the deadline, the 5 p.m. deadline, that had to be intentional. I mean, it doesn't take long to do this. They didn't input it into the court system, at noon or 3 p.m. or 4:50 p.m. or 4:55 p.m. by her deadline. They were like, let's be 10 minutes late, which is not what you normally want to be doing. when dealing with a federal district trial court. But of course, we're dealing with a rather unique animal here. The next day, Sunday, again, they have to be there by 5 p.m. And we have a different guy, right? So the first guy was Michael Kozak on Saturday. Now they're sending Evan Katz on Sunday. Who is he? He's the assistant director for the removal division of the Department of Homeland Security. In this capacity, I'm responsible for leading the division ICE air operations, which unfortunately does not include either parachutes or free fall without parachutes. I coordinate with a bunch of deportation offices. Before this, I did other things related to all this kind of stuff. I provide this declaration based on my personal knowledge, reasonable inquiry, and information obtained from various record systems, databases, other DHS employees, information portals. So this is what I think is true, but I'm in part recounting information from other sources that I just have to trust. This is protecting him from a perjury charge. He's aware of the instant, meaning current lawsuit regarding the removal of terrorist Kilmar Armando Abrego Garcia. He hyphenated Abrego Garcia, which is the proper way to do it. I noticed that unelected, black-robed, tyrannical, inferior district trial court Judge Paulison never bothers to spell Abrego Garcia's name correctly with the hyphen. Without the hyphen, it's actually an incorrect spelling. But this guy knows how to properly hyphenate this Latino name to El Salvador. I'm aware that after this court's preliminary injunction, the government sought a stay pending appeal from the Fourth Circuit and ultimately from the Supreme Court. On March 7th, Chief Justice Roberts issued an administrative stay. On March 10th, they held that the deadline in the challenged order, the Monday midnight deadline, is no longer effective, and that this court's, the court of Paulison, her injunction needed to be clarified before it would become effective. Then he starts to recount all the bad history, all the bad facts for Abrego Garcia. During proceedings in 2019, an immigration judge, where Abrego Garcia was represented by counsel, this is his due process. Abrego Garcia got all the due process to which he was entitled. An immigration judge upheld the DHS decision not to grant bond because Abrego Garcia had been grabbed while in the company, detained while in the company of a bunch of other MS-13 members, finding that the DHS determination that he was a member of MS-13 was trustworthy and supported by other evidence, and noted that Abrego Garcia failed to present evidence to rebut that assertion. The Board of Immigration Appeals, an appellate court in this process, upheld that finding of MS-13 status when Abrego Garcia appealed. So two courts now, two immigration courts, the original and the appellate court, designated Abrego Garcia to have been proven by the government to be a member of MS-13. On March 15th, 2025, Abrego Garcia, a native and citizen of El Salvador, was removed to El Salvador pursuant to American immigration law. That's Title 8. Although Abrego Garcia has an order of removal issued by an immigration judge, I understand that he should not have been removed to El Salvador because the immigration judge had also granted Abrego Garcia withholding of removal to El Salvador. So he was deportable to any other nation on the face of the earth, but the withholding of removal order says, but not except for El Salvador. But look what this guy goes on to note, which Solicitor General John Sauer has also noted. However, I also understand that Abrego Garcia, he left off the hyphen now. Look, he's doing it both ways. However, I also understand that Abrego Garcia is no longer eligible for withholding of removal because of his membership in MS-13, which is now a designated foreign terrorist organization. Also, I reviewed yesterday's declaration. I have nothing to add. No updates for this court. Done. So he doesn't even answer the first question. What's the status and location of Abrego Garcia? And he also doesn't answer the other two questions. What have you done to facilitate his return to the U.S.? What will you be doing to facilitate his return to the U.S.? This is the guy who was supposed to appear to answer those three questions to the satisfaction of unelected, black-robed, tyrannical, inferior district trial court Judge Paulison. And he didn't even make an effort. All he did instead was recount all the reasons Abrego Garcia is properly ensconced, residing at the tropical El Salvador prison resort, CCOT. You think this probably got Judge Zinnes even hotter under the collar? I would think so. And she deserves all of it. And then also yesterday, we had this defendant's response to plaintiff's motion for additional relief. So Garcia's lawyers had asked for a whole bunch of, had asked the court, Paulison, to order the White House to do all kinds of stuff. And this is the White House saying, yeah, we're not doing any of that. And this is, we're explaining here why. So this is the White House writing to the court of inferior black-robed tyrannical District Trial Court Judge Paulison. On Friday, April 11th, just this past Friday, Judge Paulison found that the White House had failed to comply with her modified order demanding facilitating the return of Abrego Garcia to the U.S., which SCOTUS never demanded. The court found defendants failed to comply with the court's order, entered only hours earlier, the night before, dark 30, directing the Article 2 executive branch to submit sworn testimony revealing sensitive information and previewing non-final, unvetted diplomatic strategies. Remember, under our constitutional order, these unelected, black-robed, tyrannical, inferior district trial court judges have no authority over national policy, foreign affairs, diplomatic strategies. None. This insane court of unelected, black-robed, tyrannical, inferior district trial court Judge Paulison then ordered that beginning April 12th, the next day, and continuing each day thereafter, the Article 2 executive branch shall file daily on or before 5 p.m. Eastern Time a declaration answering her 3 questions: location and status of Abrego Garcia, what steps taken yet to facilitate his return to the U.S., what additional steps they will take to facilitate his return to the U.S. Never ordered by SCOTUS. SCOTUS at most referred to facilitate to release Abrego Garcia. In addition, the Mad Queen court of black-robed, unelected, tyrannical, inferior district trial court Judge Paulison set a deadline for the Article 2 executive branch, for Garcia and his lawyers to seek any additional relief they would like. In response, Garcia moved for 3 categories of relief in order, superintending and micromanaging Article 2 executive branch foreign relations with the independent sovereign nation of El Salvador. In order from the court of unelected, black-robed, tyrannical, inferior district trial court Judge Paulison allowing Garcia, his lawyers, he's a terrorist, allowing them expedited discovery into an evidentiary hearing, into foreign policy negotiations. And 3, in order from the unelected, black-robed, tyrannical, inferior district trial court Judge Paulison to show cause why the Article 2 executive branch should not be held in contempt by this unelected judge. The court of the unelected, black-robed, tyrannical, inferior district trial court Judge Paulison should, of course, deny Garcia's request for these things. The relief sought by Garcia is inconsistent with the Supreme Court's instructions requiring this mad court of unelected, black-robed, tyrannical, inferior district trial court Judge Paulison to respect the president's Article 2 authority to manage foreign policy. This mad court should therefore reject Garcia's request for further intrusive supervision of the Article 2 executive's facilitation process beyond the daily status reports already ordered, you lunatic. Garcia's requested additional relief is not consistent with either the Supreme Court's order or the well-established meaning of facilitating returns in immigration law, and harbors fundamental constitutional infirmities like violation of the separation of powers doctrine put in place by our founders to prevent the tyranny they just fought a desperate 8-year war to overthrow. This court of this unelected, black-robed, tyrannical, inferior district trial court Judge Paulison should deny Garcia the terrorist request and adhere to the best reading of the amended order. On April 10th, 2025, the Supreme Court itself granted in part the Article 2 executive branch request to pause this mad court's original preliminary injunction order. The Supreme Court explained that on remand reconsideration by the court of Judge Paulison, any new order must clarify the scope of the term effectuate, in a manner that did not exceed, again, the authority of this unelected black-robed tyrannical district trial court's limits. The Supreme Court instructed that any directive from Paulison must give due regard for the deference owed to the executive branch in the conduct of foreign affairs. And it made clear that any directive should concern Abrego Garcia's release from custody in El Salvador and ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. In response, this court of the unelected black-robed tyrannical inferior district trial court Judge Paulison amended its prior order that evening to direct that the Article 2 executive branch take all available steps to facilitate the return, not merely the release, as ordered by SCOTUS, the return of Abrego Garcia to the U.S. as soon as possible. The Article 2 executive branch correctly understands facilitate to mean what that term has long meant in the immigration context, namely actions allowing an alien to enter the U.S., starting at our border. Taking all available steps to facilitate the return of Abrego Garcia is thus best read as taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. Indeed, no other reading of facilitate is tenable or constitutional here. In other words, if Abrego Garcia can manage to show up to U.S. port of entry where he would not normally be admitted because he's a deported alien, ICE can allow him to come into the country. That would be facilitating his return by this reading, the proper reading of what facilitate means as a legal term of art in the immigration context. This reading follows directly from the Supreme Court's order, you dummy, holding that any directive must give due regard to the executive branch's exclusive authority over foreign affairs. That means the judicial branch has no authority over foreign affairs. Zip, zilch, nada. To contextualize it for the facts of this case, this use of the term facilitate tracks long-standing executive practice, and it comports with how the federal courts have understood the outer boundaries of their own power. You hear that? Unelected black-robed tyrannical inferior district court judge Paulison, believe it or not, there are bounds to your power, to your authority, to your jurisdiction. It has limits. Queen, on the flip side, reading facilitate as requiring something more than domestic measures like foreign policy negotiation, like flying Abrego Garcia back at U.S. government expense or arrangement, as requiring something more than domestic measures would not only flout the Supreme Court's order, but also violate the separation of powers. You know, the doctrine our founders put in place, creating different branches of government so that power could not be concentrated to the benefit of tyranny, very deliberately structured in that way, that the Article 1 legislative branch and the Article 2 executive branch and the Article 3 judicial branch each have their own set of core and plenary powers that are not subject to infringement by the other branches, but for when the Constitution explicitly allows. And the Constitution does not allow the Article 3 judicial branch any role in foreign policy, foreign relations. Continuing, the federal courts have no authority to direct the executive branch to conduct foreign relations in a particular way or engage with a foreign nation in a given manner. That is the exclusive power of the president as the sole organ of the federal government in the field of international relations. Such power is conclusive and preclusive, I would say core and plenary, and beyond the reach of the federal court's equitable authority. You are exceeding your authority. Empress, plaintiff's additional relief, Garcia's, the other stuff he wants, runs headlong through this constitutional limit. The terrorist Garcia asked this court to order the Article 2 executive branch to make demands of the El Salvadoran government, dispatch personnel onto the soil of an independent sovereign nation, and send an aircraft into the airspace of a sovereign foreign nation to extract a citizen of that nation. Abrego Garcia is El Salvadoran from its custody. All of those requested orders involve interactions with a foreign sovereign and potential violations of that sovereignty, acts of war. Are we supposed to send SEAL Team 6 into CCOT to extract this terrorist, Kilmar Armando Abrego Garcia's, who's had a final order of deportation in his back pocket for 6 years. But as explained, a federal court cannot compel the Article 2 executive branch to engage in any mandated act of diplomacy or incursion upon the sovereignty of another nation. Garcia invites this insane court of unelected, black-robed, tyrannical, inferior district trial court judge Paulison to exceed its own authority in the precise sort of way the Supreme Court cautioned against. Dummy. This court of Paulison should decline that terrorist's invitation to exceed its own authority. Also, no additional relief is warranted for the terrorist Garcia at this time. Consistent with this court's latest order, defendants are providing daily status reports that share what they can, which is how the Supreme Court phrased it, as the government determines an appropriate course of action. Although the Article 2 executive branch was not prepared to share information with the court within hours of its order, the Article 2 executive branch responded to the first of the court's questions, what's the location and status of Abrego Garcia, yesterday evening, and confirmed that Mr. Abrego Garcia is alive and secure in the custody of El Salvador at the tropical El Salvadoran prison resort of Terrorism Confinement Center, CCOT. It is now public information that the president of El Salvador is currently in the U.S. and will be meeting with President Donald Trump on Monday, April 14th, today. The Article 2 executive branch will continue to share updates as appropriate, meaning as we, the Article 2 executive branch, deem appropriate. You unelected, black-robed, tyrannical, inferior Article 3 district trial court judge. Any further intrusion into this sensitive process and any directive from the court of this unelected, black-robed, tyrannical, inferior district trial court judge Paulison to take action against the nation of El Salvador would be inconsistent with the care counseled by the Supreme Court. As discussed above, this insane court should decline the terrorist Garcia's requests as to the steps both exceed the requested steps both exceed the Article 2 executive branch authority. I don't think that's what they mean. That must be a typo. As the requested steps both exceed the court's authority, I'm sure that's what it's meant, and are inconsistent with the Supreme Court's direction. The court could not and should not enter an order directing any of these steps asked for by the terrorist Garcia. For many of the same reasons, this insane court should deny the expedited discovery requested by terrorist Garcia. This discovery, including the presentation of live witnesses, would probe the Article 2 executive branch's preliminary thinking on diplomatic efforts and would go well beyond requiring the Article 2 executive branch to reveal what it can about the status of this process. Remember, what it can is all the Supreme Court ordered. That request is particularly inappropriate for discovery by a terrorist into American foreign policy negotiation. That's insane. That request is particularly inappropriate given that such discovery could interfere with ongoing diplomatic discussions, particularly in the context of President Bukele's, president of El Salvador's, ongoing trip to the U.S. In addition, terrorist Garcia asks for documents reflecting the terms of any agreement, arrangement, or understanding regarding the government's use of CCOT to house U.S. deportees. It calls for the immediate production of classified documents for a terrorist, as well as documents that the terrorist Garcia, that Article 2 executive branch may elect to assert are subject to the protections of attorney-client privilege and the state secrets privilege. It would be inappropriate for this court of unelected, black-robed, tyrannical district court judge Paulison to hastily order production of these sensitive documents, particularly where the Article 2 executive branch are continuing to regularly update the court here. Update kind of as they can. Finally, the court should not issue an order to show cause for contempt. Terrorist Garcia began their motion with a quote from the president confirming his respect for the Supreme Court and intention to comply with its order. The Article 2 executive branch remains in compliance with the Supreme Court's order. That's the Supreme Court's order, you lunatic, not that of a black-robed, unelected, tyrannical inferior district trial court judge like you, Paula Zinnes, based on the Supreme Court's order and respect for both the executive branch's authority over foreign affairs and the sovereignty of El Salvador. Why do you hate El Salvador, Judge Zinnes? Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.